Okay, I sincerely apologize for the delay. I know I called for 3 p.m., but we just finished our SNIL session, so we will rise in just about a minute. Thank you all for your patience. And I believe at this juncture we are in our Q&A session with the commission. So I now open the floor to any of the members who would like to ask their questions. Floor is now open. And for the record, I just wanted to share too that this morning we received a public comment via email from Mr. Melvin Faisal, which I shared with the members. I just want to state that for the record so that we can have it as part of our communication. Okay. Senator Donald.
Thank you, Chair. Welcome back, Commissioner. Just to kind of follow up some of our discussions earlier, I want to ask, since IPI has stopped paying the commission, and since the time you guys ran out of funds, how much in liabilities have you incurred today? Is that something that you have with you right now?
The IPI ceased paying on the fees for 2020. But since our funding does not lapse, we have kept up a reserve, and we kept CCC alive from 2020 to the end of 2022. So our actual complete no funding, and including termination of employees, began in January 2023. So at this point in time, our liability is on the office rental and on the right now the commissioners. There's currently 4 compensation, and that's it. No employees.
Do you have 30? Did you say 34?
No, for the last day, it's the January 2023, starting to today.
So how much in liabilities have the commission incurred?
I can get that to you for the office rental. It's $10,000 a month, and it's about 2.5 years. And the commissioner at 65, there's 5 for 2023. I can give that to you, the detail follow up.
Okay. Now, you also mentioned earlier that in the event, maybe whether it be Team King or some other investor gets the license, you do have employees that are ready to come back to work, or is it something that you would have to go out and employ again and train?
What the cost that has been incurred, we had always planned that it would be paid from the fees, from IPI's regulatory fees. Now, when we let go of all the employees in January 2023, quite a lot of them have expressed early that when funding is available, please, we want to come back. They have communicated to me throughout this month, and majority of them are standing by to come back to CCC. Once we have the funding to hire them back, and these are people that are highly trained in their area of specialty, with specific in the issues of compliance, the audit, and the enforcement investigations. They're standing by to come back, but if the money is available, what we would do is announce the position, and we will entertain their application back. CCC has their own personnel system. We do not go through the Office of Personnel. So all of this we now have an autonomous, as an autonomous agency, we have developed the regulations to manage our own personnel.
Okay. Now, again, going back to the discussion with the court possibly dismissing the case in the event the liability insurance is not something that they're able to provide. If that is the case, and if the court dismisses the entire thing, is the commission ready to revoke the license, or what will be the next step?
A couple of issues, but first, I noticed that Mr. Robert Glass is in the gallery. He is supposed to be representing the Commonwealth on the bankruptcy. So I would encourage that the committee take the opportunity to ask those specific questions. But I've been informed over lunch that Team King or IPI has already paid the insurance and they're just waiting for the notification to come up, which was the issue you raised earlier. My position is that if it does not go through and the Chapter 11 bankruptcy protection is dismissed and we go back to complete liquidation, I see no reason at all why the commission could not reconvene its casino revocation deliberation. Remember that we already completed the revocation hearing and we're in the deliberation phase. And just as the final phase come out to revoke, that's when the bankruptcy protection came in and we were prohibited from proceeding. If there's no more Chapter 11 protection, I would expect that perhaps with the assistance of the Office of Attorney General, we can proceed and complete the deliberation and revoke the license. And if the license is revoked, then if the Commonwealth wants to continue, then there's a license available. And I would expect that perhaps the CCC save money. I mean, I'm interested to see where is that.
Okay. And just one last clarification. Again, according to the news, it seems like there are 3 different routes that may happen moving forward. One would be the dismissal in the event they don't submit the liability insurance, but it sounds like they have done that. And so the court may proceed, and so that brings us to the next 2 options, which is convert this case to a Chapter 7 or appoint a Chapter 11 trustee. Based on what you're familiar with, what can we expect within the 2 options that was presented, and I guess what's the anticipated timeline if we go either, if the court takes it in one of the other possibilities?
My understanding, during lunchtime, I was informed that IPI has paid the insurance and that they will notify the judge by this Friday by issuing the insurance notification. The winning bidder, Team King, was scheduled for, I believe, June 13 for status conference. They gave them about a month to consummate whatever their complete bidding was. And prior to June 13, there was a request for extension of the status conference to June 27. Again, this is not coming from our assigned attorney, but this is what we're reading on court record ourselves. So I would expect that by June 27, whatever the stipulation was, the time that they won the bid, there's 12.9 million funds to be disbursed. I would expect that those people that are supposed to receive money should have been paid during this period, and on the status conference is to make an update to the court as to how this distribution, or I don't want to call pro rata distribution, but whoever was owing, whether they got paid and how much. That was supposed to be and another information that I cannot verify the authenticity of this, but and perhaps, like I said, we have an attorney here representing the Commonwealth. We should be the one talking to this committee. But from what I'm hearing, Team King and Public Land are having a little issue regarding either bonding or requiring a significant amount of money to be deposited. And that's a negotiation ongoing right now. And that's what I've been informed by one of the parties. Now, there's also some optimism that perhaps that would be resolved by June 27, so that the status conference would be more clear as to how the proposed distribution of those limited cash and a lot more there's a 125 million liability and only 12.9 million in cash. So that there's supposed to be an update on that. Is how is that to be distributed? Um, like I said, even on the CCC, we've been advised by our counsel that if we go pro rata is one way, or we can negotiate with Team King to cure the deficiency. So obviously, it doesn't take a rocket scientist to see that curing the deficiency would be better off to CCC than to receive a pro rata distribution, which could be a penny on the dollar or nothing. Since we are unsecured creditor, we're like not high on the hierarchy of priority.
So what you're saying is that they will need to address the 109 million before moving on with.
I think with somebody, I'm not from public land, and I understand that they have responsibility to take care of our indigenous land, but I think people need to wake up and realize that this is a very serious economic times. And from my perspective and my discussion with the governor before is that when they were asking to negotiate and stipulated, make agreement to, talk about depositing something and then making partial payment plan, my recommendation to the governor is that we should listen to what IPI is offering. So our concern is finish the IPI building and then have them make arrangements to pay everybody that they owe. They may not get it up now, but make payment plan. That was something that was not accepted, and that's why we pursued the first. Initially, the government was pursuing Chapter 7 with the advice of the attorney, but then the court honored the Chapter 11. But then again, now they're entertaining possible Chapter 7.
Has there been any? When's the most recent inspection report or assessment of the current IPI building, and what the cost would be for Team King to take over and fix whatever deficiencies there are, and if that's still something that Team King is ready to
unofficial unofficial report is that because it's kind of difficult right now because there's no power in the area, and all the inclement weather may have caused some leak to the roof and some of the rust proofing area. Last estimate that I was informed by IPI was that it would cost between 150 to 200 million to finish the facility. And previously, Team King's CEO, Mr. Hiroshi Haneda, had offered to invest 350 million of the Japanese bank to finish the facility.
But that 150 to what was that 250? That was a report done years ago, or
Though years ago, when I asked IPI to provide financial suitability document to show that you are financially suitable, one of the documents they produced was an agreement with a group of Japanese banks, which is Mr. Hiroshi, $500 million of commitment for the bank to help IPI finish the facility. Of that amount, IPI have already spent 150 million of the 500 million as part of the ongoing construction of IPI. So there's still remaining 350 million that the Japanese continues to offer, even before IPI filed for bankruptcy.
Yeah. And one last clarification: the negotiations with DPL, did this occur with the prior secretary or the current acting secretary?
With DPL,
Yes.
I believe that DPL is only is part of the, when they won the bid, and this is also some of my questions that continue to be unanswered. When they offered the $12.9 million bid with a certain assumption of liabilities, some of those assumptions would include the ongoing leasehold obligations of IPI that Team King must assume. But we are left in the dark by our own counsel in that area, so we're not privy.
In regards to what's going on with DPL.
Yeah.
And so, with IPI, the lease agreement was between IPI and DPL.
Yes.
And has DPL revoked?
I'm not
Have they
quite
done any
sure. They
revocation?
threatened a couple of times because of the delinquency. Where the casino is, I think it's over 19,000 square meter of public land, and then there's a couple more private land within the Garapan casino. So on the public land, they have a lease, and that's, I believe, is what they're trying to transfer the leasehold over to the to the bidder, the winning bidder. Um, I'm not quite sure what the negotiation is right now.
Okay. But as far as you're concerned, you're not aware if there's still that active lease between DPL and.
Yeah, I believe it's still active because there's a $230,000 a year payment, and they were in arrears. But last time I looked at it, they said they paid it. But now all of this stuff, the winning bidder is supposed to assume those monthly leasehold or yearly leasehold payment, and also the insurance. The winning bidder is supposed to assume that, but something interrupted in between, so the timeline didn't quite fit. But from what I heard again this afternoon, I'm not. If the insurance is paid, so what you're reading on the newspaper regarding the judge will not wait for June 27, that he may just dismiss the case if the estate is not insured. That particular concern, I was informed, has been resolved, and it's been paid, and the actual insurance notification will be given to the judge on Friday, this coming Friday.
Thank you for your input. That's all I have for now, Chair. Ayun.
Thank you, Senator and Chairman. Senator Calvo, did you have any questions you'd like to ask?
Good afternoon, Chair, and thank you, Chairman. One of the things I was just thinking of is the transition. If this executive order is in place, and knowing your scope of work is the enforcement portion of it, and the operations, the expertise. I was thinking of the employees and stuff when it gets, per se, handed over to the Lottery Commission. In your opinion, do you feel that they are equipped to handle the duties and responsibilities of the CCC at hand, and to what magnitude, how significant would that be if we know that there's an existing investor, Team Kin that you mentioned? Would it hamper or delay not only that, in regards to the legal aspect of it?
Thank you, Senator. I have nothing bad to say about the past or present members of the Lottery Commission, but these folks are occupying major departments. Department of Public Safety, Department of Commerce, and Department of Finance. The casino itself is a 24/7 operation. It cannot have a part-time, whenever you're available, kind of commissioner to sit in on critical issues that may involve a decision on the floor. That is why we're asking that this particular executive order will not work if the intention is to do our due diligence here in the Commonwealth. If the intention is to have a robust regulatory agency, moving it to the Lottery Commission is not the right move. If the intent is to centralize, unify, then it's best to look at what's happening with our poker. It's being managed by finance. What's happening with our e-gaming? It's managed by finance. What's happening on the lottery? I don't know what lottery. I think Utang. It's managed by the Lottery Commission. And what's happening with the casino? On Saipan, it's the Casino Commission. On Rotan Tinian, they have their own regulatory. So it makes sense in some jurisdiction where all gaming goes under one umbrella. All gaming. Whether you are e-gaming, whether you are poker, or your casino or lottery, goes under one umbrella. And that one umbrella should be a full-time entity and should have their own very robust regulations, and including the one I was talking to you about, the mix You must have those in order for you to have a strong regulatory regime. You cannot have this fragmented system. I understand that poker and TNN and Rota have a separate arrangement on the funding, but I think that to regulate and monitor it, it can go under those casino commission rather than under Department of Finance, because the casino commission is more, whether Saipan, Rota, or TNN, are more trained to deal with the gaming aspect of it. And by the way, when we regulate, we don't just collect the fee. We regulate the vendor who sells those slot machines. We test those slot machines against the GLI standards. The current slot machines are no longer drums, they are computerized machines. And they have standards, international standards, that our staff have been very trained on. And every machine, we do audit on the machine's performance. So we monitor their outcome and we watch for any variance either above or below what the expected outcome to make sure that these machines are not cheating. Those come into our compliance team and reviewed by our audit team. And we regularly work with a company of Australia, the GLI. They're the ones that develop the international standards to make sure that every machine, every gaming equipment meets those standards. From the time that the machines are sold, the seller we have to license, and the machines have to be tested against the GLI standards. The results of those tests are sent directly to CCC, and then when it comes here, we compare them because those results are like fingerprint for each of the machine. And if the machine is not corresponding with the source code, we do not allow it to go to the floor. And we have a machine called Cobatron that can pull up the EEPROM, the chips, to test each of the machine to make sure it meets the standard. These are issues that I don't think was thought about when they attempted to transfer this to Lottery Commission. It's kind of, even after we test all the machine and even after they assemble here in Saipan, they set it up in the case of IPI. They have a warehouse in San Antonio, and when it comes in on island, customers will call us and said the machines are here. We escort them all the way to San Antonio. The machines will be taken out of the container, laid out on their floor in San Antonio warehouse. They begin to assemble over there, and that's where we test them. When they meet all the GLI standards, we allow them to take it apart and bring it to the casino floor. And then when it gets to the casino floor, they would ask us to go into what we call interoperability tests. They connect to the casino case management, and they run it for 24 hours to see if these machines are speaking to the mainframe. If it is speaking, then they ask us for authorization to go live. We looked at it. We have our compliance team down watching it with them. And then they will also verify with me that yes, those machines have complied. We then at that point in time give them the green light to go, and we will put the CCC seal on the top of each machine. We put it on the top because the eye on the sky is looking down at those machines, and we track those machines. So yeah, from the regular, even the chips, we regulate the chips, the description of the chips, the weight of the chips, and they are made. The $1 million plaque are made in southern France, and the cheaper ones are made in Mexico. We license the manufacturer. We license them when they make them. And we have to approve the chips because these are property specific. So the chips that we authorize at the T Galleria cannot be used at IPR. These are completely new. Unlike some places like in Vegas where one operator may be running 3 different property, some of those places they can allow one chips to go to the other property. In our case, it's a property specific. You can only use that chip in that casino property. But we regulate the chips and we monitor the chips regularly. We have an entire compliance team that looks at that. By the way, before I leave, sir, I would really recommend, since you're representing Rota, ask them to look at the minimum internal control standards for all gaming. And if they need help, CCC will help.
Yes, thank you for that advice. Even the outer islands, how you're mentioning, what impact will it have on the Tinian and Rota, gaming in regards to the rules, regulations, and also their statutes in place as far as the outer, islands. And if this one is, but taking a look at this, it's kind of like, the EO 2025-02, transfer of authority for supervision. This is the subject, the order. Transfer of authority for supervision of casino gaming from Commonwealth Casino Commission to the Commonwealth Lottery Commission. So just looking at that transferring of a supervision, and then you have the two laws, then, the purpose of trying trying economic times necessitates consolidation of duplication government. So governmental duplicative government instrumentalities to ensure the Commonwealth limited fiscal resource are allocated to provisions of essential public service. Reading that purpose, meaning that you are not, the abolishment of the CCC in regards to this is like in collaboration together as one versus, you know, abolishing CCC at what point? That's the big question. At what point is this transition going to happen from CCC to CLC? And that's just my thought behind it. Is if it's streamlining, it'd be a transitional process versus, okay, we're coming in, we're going to take over because your expertise, everything that you're explaining is key elements and time and service and investment into the whole gaming industry. So that's one point we have to look at. And the other thing that I was taking a look at is, the enactment, Section 1. These are enactments where the CLC has the authority to enforce, based on the executive order. Just looking at all that, the enforcement part, and being able to negotiate, the accrued amount of any encumbrance of said licenses. So these are some of the things that I was just taking a look at in regards to how it will affect us if this were to transpire.
Senator, if I may, I do not think that the function that the Lottery Commission is doing and what the Casino Commission is doing is duplicative. I don't think we're duplicating. My understanding of the effective date is that 60 days from the time that executive order is issued and given to the legislature, it comes into full effect. And one of the sections there, I believe it's section C, it basically says, CCC, you are all terminated for costs, which is a very dangerous word to use when there's a different definition on costs under Constitution and under statute. But it appears that 60 days, CCC is fired, the commissioners. So if your concept of transition ends in 60 days if it is not rejected. Now, if you look at the Constitution, as you all know, casino gambling is prohibited by the Constitution, except if it's passed by local initiative or by Commonwealth law. Rota and Tinian did theirs by initiative. The CCC was 1856 was created by Commonwealth law. And in that Commonwealth law, it required a representation from Rota and it required a representation from Tinian. That's why we have commissioners from those jurisdictions. There are none under the Lottery Commission. When you abolish the CCC, you abolish those direct representation from Rota and Tinian. I mean, that's the way we're looking at it, because the commissioners from Rota and commissioners from Tinian are very important members of the commission and very outspoken members too. You move it, if you kill CCC in its current structure, I do not see that under the Lottery Commission.
You're done.
thank you for that point. So that's CCZ's argument in regards to the clause for termination. Should that power be vested and these choices are to be implemented? Yes, thank you very much.
You're welcome.
Thank you, Senator, and thank you, Chairman, for explaining the complexities of the duties and responsibilities of the commission. Many of the members do want to know whether the justification on the executive order is indeed valid, where the governor states that the roles are duplicative, and as you stated, they are not. And that is why we also intend to invite the Lottery Commission to also get an understanding of what their thoughts are on the executive order. Obviously, they report to the governor, so they will fulfill and comply with what the executive order is asking. But I think it's also important to understand the impact that it would have on the CNMI. And so, because this is a very time-sensitive matter, we are given 60 days for the legislature to act on it or reject it, modify. We are working very diligently to collect as many information as possible, trying to understand the legality of all of this. And Senator Calvo raised a really good question. I think, just for clarity, I don't think he meant like, can the Lottery Commission do the job personally in their capacity? I think where he was leading is the roles and responsibilities. As you explained earlier, there's a lot of meticulous duties that the commission performs, and whether or not the Lottery Commission is ready to take on that responsibility and are properly trained. Those are some of the concerns that some of the members have, to ensure that should the executive order take effect, that there is a sense of responsibility of the transferring of those duties and responsibilities. And I think you pointed out in the letter that you submitted to the Senate President and Speaker Villagomez back on June 12th, I believe on page 4, number 4, you did mention about the CCC's authority. So let me just read it out for the members and the public who are listening or will be listening. The CCC's authority is grounded in law, Public Law 1856, and subsequent legislation created an independent regulatory body with protections against political interference. The executive order's attempt to dissolve the commission states no grounds that meet the legal standard for removal. Under Article 3, Section 21 of the CNMI Constitution and subsection 23D of Public Law 1856, the term cause is defined as gross neglect, breach of fiduciary duty, felony conviction, or mental or physical incapacity. The executive order fails to articulate any grounds that meet this Constitution and the statutory threshold. These raises significant legal concerns and exposes the Commonwealth to potential liability should the matter be challenged in court. I think this is a very strong statement that you have provided, and it's definitely something that the committee will do a little bit more research to ensure that there is no, whatever that legal impact that it might have, that we do the responsible thing and ensure that the Commonwealth is first and foremost our our priority and our focus in all of this. We're still doing a lot of research into this executive order, and I just wanted to go back into your letter where you had stated, this is kind of leading to what Senator Calvo was asking on the transition. So should the EO go into effect, let's say the legislature failed to act on it and it just goes into effect, what are some of the potential ramifications, in your professional opinion, you think this would happen, knowing that the Lottery Commission is, I don't think, and I could be wrong, that the Lottery Commission has gone through the rigorous and extensive training that you guys have received. So, knowing that, what are some of the potential implication of transferring duties or responsibilities to a body that has no formal training or education on the type of work that you guys do?
With all due respect, Madam Chair, I'm not quite sure what the lottery commissions have in mind in terms of assuming this responsibility, and I hesitate to speculate where they are going. But it appears that if the Commonwealth does not like casino and wants to kill it, this is a good way to do it. Go for it. Transfer it to the Lottery Commission. But if you care about having a robust regulatory entity, and you care about the casino working as part of our alternate industry, then I see no urgent reason why all of a sudden now, just as Tim King is coming into the picture to be investigated for due diligence, just that in the process of doing our work, to come in and sever it. As I indicated on that June 12th letter, this is all contrary to common sense, and it will frustrate the Commonwealth's ability to complete on a timely basis the due diligence requirement to look at Tim King. Although when they included the license as part of the auction, it was with the understanding that Tim King had 9 months to secure the license from CCC. If after 9 months and the license is not issued, it was, according to the court procedures that we were reading ourselves, it will be considered rejected. And if it's rejected, then that means the exclusive casino is available to be licensed elsewhere. So, going back to, I hesitate to speculate what the Lottery Commission would do. Again, with all due respect to the past and present members of the lottery, I know that the Secretary of Commerce was IPI employee, and she was helping IPI on the last days on the compliance. And she understood because we put her through the certification to understand anti-money laundering requirement. So she had to go through that in order for us to license her. So she understood the complexity of regulating the casino. But I'm not. I wonder if the Lottery Commission have ever been consulted either, because I feel like reaching out to them, asking them that same question: what do you have in mind? How do you propose to do this? I care for this Commonwealth. If I don't care for this Commonwealth, I throw in the towel a long time ago. But I think it would be reckless on our part to drop the ball. And I think we are at the verge of having a new operator come in. And we watched this Japanese, and we understood he has that 350 million sitting there ready to be invested on finishing. And I think there is a very hopeful opportunity for gaming to be restarted. And I'm sure that even themselves, they want to have a strong regulatory entity. No casino operator, a legitimate one, would want to operate in an environment where there are no regulations. It will never work. They want a strong, robust regulatory entity. And that's the way that they can operate cleanly, and that you have good reputation too on the outcome of their operations. But I'm not quite sure what the Lottery Commission would do. I wish they were here, because I'm interested to hear too what they have in mind, if they were consulted at all.
Okay. Thank you for that answer. Let me ask you this: has the commission reached out to the Lottery Commission to start dialoguing about the potential of this executive order going into effect?
No, we have not. We're battling right now with the Secretary of Finance because of the instructions that the AG gave her not to release the appropriation that this legislative body had legally appropriated 250,000 for the CCC to compensate past board compensation that the AG's office instructed finance do not pay that because they have no money under Schedule A and there's no public purpose. We are looking now that this is a liability on the Secretary of Finance
Got it.
because she has the authority and the responsibility to issue payment. And the fact that she's denying it is a denial of our right. And we are pursuing this with that person
Okay.
personally. So this is an issue that I'm not reaching out to her. She's a member of the lottery.
Right.
And I haven't reached out to Remy, the commerce, but we know Remy. She's a wonderful lady, and she'll probably have a greater appreciation of regulatory bodies. IPI assigned her to handle compliance, IPI's compliance, and she understood how we went after IPI really hard as she was trying she was defending IPI on a lot of the compliance issues.
Thank
I
you.
don't know about Mr. Macoronas at DPS.
Okay. Thank you for sharing the background on that. I mean, I see that as a different issue, right? That's a completely different issue from the executive order that's in front of us right now that we are trying to see what to do with it. I mean, I would encourage the Casino Commission to reach out to the Lottery Commission, whether it be the Secretary of Finance or the other members, to start the conversation and prepare for the just in case, right? Because the time is very limited. 60 days is just around the corner. I believe we need to act on this by August 1st, which is a little bit, just a little bit over a month from now. I think it's important that the conversations need to start planning on what the contingency plan is looking like as far as transferring of duties and responsibilities, just in case this goes into effect. I think that would be the responsible thing. As you have mentioned earlier, there's a lot of the role, the duties and responsibilities is so complex that I feel like there's a lot of information, a lot of training, a lot of just all of that to transfer and for them to hit the ground running. So time is of the essence. I think we're running out of time. I understand that the Casino Commission is having some issues with the Secretary of Finance, but that doesn't mean that the other lottery commission members are unapproachable or unreachable. So I would encourage the Casino Commission to please start reaching out to the other lottery commissioners. Sure.
I asked, Madam Chair, that you also asked the Lottery Commission to reach out to the Casino Commission.
I can definitely
You know what I mean?
share that.
Yeah,
share the message.
somebody attempted to strip us of everything, and we find it odd that we're going after to try to say they should be the one coming to
Yeah.
the commission saying, "Hey, this has
I
been
mean-
thrown to our lap. Can we can we discuss this?"
Sure.
None of them have reached out.
Yeah. Well, and I'm not trying to defend
Yeah.
the Lottery Commission, right? They're just basically taking orders from what this executive order is requiring of them. So I feel like the onus and responsibility should come from the Casino Commission in saying that, you care about the Commonwealth's well-being and how this is going to affect a lot of the work that's ahead, especially with the new owner coming into, and there's another timeline of 9 months. I just feel like there needs to be planning like last month, right? Or whenever this came out. So I would just encourage, I know that you have your differences with the Secretary of Finance, but I think it's important for the betterment of the Commonwealth that we put all those other differences aside and focus on the executive order and see what we can do together. I can't speak for the rest of the members here at the Senate and as well as the House. There currently, as I know, there is no position either way, whether to reject, to modify, or accept the executive order. As I said earlier, we are in the stage right now where we're gathering a lot of information and just doing a lot of research to better understand the legality of the executive order and whether or not, obviously we know that the governor has the authority to issue such order, but the way it was done, or maybe some of the justifications that were provided on the executive order, those are the things that we're looking at. So from the technical standpoint, that's what the committee is looking at to ensure that there is fairness, equality, and at the end of the day, just making sure that our CNMI is protected, and we try to avoid or prevent any potential liabilities in the future from, so there's a lot of pressure and burden on the committee to do its due diligence and to ensure that we make the right decision, the responsible decision, right, for the betterment of the Commonwealth. I do have Senator Carl online, and he does have some questions that he would like to ask. So, Senator Carl, are you still there?
Yes, ma'am.
Okay, please proceed. Thank you.
Thank you, Madam Chair, and thank you, Commissioners, for being here this afternoon again, once more with us. I really feel as if the whole dialogue of our meeting and what has been discussed cuts to the core of the reason behind not supporting the executive order. And I'll ask my questions, but please allow me to expound. Here we are talking about whether it should be CCC reaching out to the Lottery Commission reaching out to CCC, who should do what first. I firmly believe that in the statute of 1856, therein lies the vehicle for any modification to the Commonwealth Casino Commission. All of these things are being put on our table with a drop dead date of 60 days. And because we're being put under these pressures, obviously it feels like to me, and please correct me if I'm wrong, that there is no standardized procedure for you guys as commissioners to properly execute the mandates of this executive order within the time frame. So my first question is, do you guys have a protocol for this in place?
No, not this particular situation. But you made a valid point, and that is there are mechanisms in which we can amend our gaming laws. And we have approached the legislature previously with some suggested changes. When you asked us what do you think needed to be done, I submitted some suggestions on how it could be done. And I still take the position that even if Tim King were to continue, they are still requesting at least IPI before Tim King step into the picture about reduction in license fees. They think 15 million is excessive, and I think we told them that we will not object if you go to the legislature and seek their assistance. But if the legislature looks at amending the license fees for, let's say, for discussion purposes, to reduce it down to a realistic amount, then that would be the mechanism in which you're not touching 1856, and you can make the modification to change. If at that point in time,
within the rules.
if at that point in time you think that CCC need to be abolished and replaced by, then that would be probably you have more time to discuss this thing, to look at the pros and cons. But to have the 60-day window of either modify or reject, or it becomes law, I think it's a very dangerous precedent to touch, particularly on an industry of this magnitude that requires a very strong regulatory regime. But do we have a protocol right now? No. Not to transfer the management from us to the Lottery Commission.
And I can understand your frustration. Obviously, 60 days is not a lot of time. That's just around about 2 months while you're currently doing the job that you were intended to do. I guess it would mandate you to put together some kind of documentation to transfer in hopes that whoever that the lottery commission could onboard quickly and would know enough to render their opinions as it relates to gaming in, matters within the Commonwealth. And my concern is that again, I don't mean this to cast aspersions at anyone. As you had alluded to earlier, the Secretary of Commerce was a part and took some courses and was able to identify and understand some of the components as it pertained to gaming. But my concern here is not only is there not a protocol in place for the execution of this magnitude to transfer over the duties and responsibilities from an organization that was created by Commonwealth statute over to, and then correct me if I'm wrong, the Commonwealth Lottery Commission was never meant to be there permanently. So I guess my concern is two pronged. If you don't have any protocols in place, um, and this is a very contracted timeline, how would you guys even begin to execute the transfer of information and institutional knowledge that you guys have under your purview to the Lottery Commission?
We don't have. There is no mechanism to transfer such a short period of time. And if you've been fired, do you feel inclined to help the person that fired you? I mean,
I'll,
I
I'll,
find
I'll, I'll I'll leave that. I'll leave that, Commissioner. Respectfully, I'll leave that one alone because I want to kind of move on. But I understand what you're saying. I understand what you're saying. But you did talk earlier on about the leadership. As you spoke to Governor Torre Palacios, he did express to you that Tinian did not want to appoint a member to the CCC. Is that correct?
the governor himself told us, me and the vice chair, when I asked him in his
Okay.
office that we need one more commissioner from Tinian. He said he's not appointing because he's been asked by the Tinian delegation, mayor, and delegation to hold on the nomination. I That came
Okay.
from the horse's mouth.
So thank you for that. Thank you so much for that clarification. And just to set the record straight, I am a member of the senior leadership. I am also a member of the delegation, and none of those questions have been brought forward to the senior leadership or, to my knowledge, the mayor's office. Because the mayor, I do know, will not speak on behalf of the leadership without our opinions and our input. So thank you for clarifying that up to the public. Secondly, you guys have you in the morning session you spoke about a lot of the trainings that you guys have done. Obviously today, this afternoon, you've spoken about in great length to a lot of the nuances and things that you guys have to do with the devices to ensure that they're compliant. And my question is, throughout your trainings and through all the times that you guys interface with IPI or whatever operator, was the lottery commission a part of any of those engagements?
The answer is no. And I tell you, it bothered us when IPI needed to make some amendments to the license. Section 2 of that agreement, casino license agreement, says that once the license is issued, the authority of the Lottery Commission over gaming ceases, and the Office of the Governor assumes the responsibility to enforce the terms and agreement. Unfortunately, when IPI requested, apparently there was a one-page legal opinion from the AG's office that says that the Lottery Commission still has the authority to entertain amendment. So with those, the Lottery Commission made 9 amendments to the casino license. Um, and we reach out to them to say you need, sometimes we go to the meeting to provide them consultation, but and in some of the amendments I think it makes sense and it was a valid change, but
Mhm.
no, even though the agreement says it's the Lottery Commission's authority stops once the license is issued, they continue to entertain amendments. And when I
Can
inquired,
I?
I was told that since the amended law did not specifically prohibit lottery commission. So I assume that the logic was the entity that entered into it continues to have the authority to amend it. So all of those 9 amendments was done by the lottery commission with no input from the CCC, no solicited input. But we had to submit written opinion to make sure that those issues are addressed.
Would it be possible for you to furnish us the paper, the opinion from the AG's office, as well as the paperwork that you had submitted
Um,
to the members of the committee?
they never provided the legal opinion to CCC, but I read it from one of the members who showed me. It's a one page, and I read it and it's signed by Manbusan. So I figured, okay, they gave him the authority to entertain the amendments, but we never got a copy. Just like we never got a
So
copy of
just
the
to clarify,
executive order. I'm sorry, sir, I didn't hear you.
wait, is it an executive order or a legal opinion?
I saw a one page opinion.
So a legal opinion
Yes, yes.
from the Attorney General's
From the
office.
Attorney General, signed by the Attorney General. The Lottery Commission can
But you don't
perhaps.
have a copy of it in your
I
possession?
do not have a copy. They only made me read it.
And when you say they, who is they?
A Lottery Commission. I forgot which member.
And who are them? Could you name them
The,
out, please?
the member at the time was Rabolaman. I mean, Larissa Nelson. What's the one that comes? Robert Guerrero from Commissioner, the late Robert Guerrero, and
Mhm.
the chair, Margaret Bolliman. Margaret Bolliman was the chair. The other member is late Robert Guerrero, and Larissa, and also from Larson from.
And just for informational purposes, was this an actual hard copy of a legal opinion, or was this shown to you via some kind of
I read the hard copy.
electronic device?
I read the hard copy.
Okay. And do you recall who signed off on the legal opinion?
I remembered Edward Manibusan's name on that opinion.
Okay.
We can
Now,
probably.
in the
ask-
go ahead.
I was thinking that the committee can probably get the lottery commission to provide you that. But they say that these are all attorney-client privileged information. But once the attorney gives that to the client, it's up to the client to figure out where it should go.
Understood. Well, I thank you guys for your time. I understand that there's a lot for the committee to unpack. I'm very wary to proceed forward because of the multitude of issues that have arose just from discussion. We're not even talking about implementation. And if we can't even get the discussion down to a place where it's somewhere feasible in our mind's eye, then I don't understand how we could possibly move forward with effectuating this executive order in the manner that is meant to be set out. So that's just my opinion, and I'd like to thank you again for your time and your patience today. And I'll yield back, Madam Chair.
Thank you, Senator, and thank you, Chairman. Any other questions from the members? I know it's past 4:30, but just one last clarification, Chair. So on your June 12th letter, in the beginning of the letter, you wrote that the CCC feels that this executive order will delay the timely suitability review of the new casino operator, handicap the CNMI's ability to properly regulate the casino industry, further frustrate the CNMI's efforts to improve our economic recovery, and is ultimately not in the best interest of the Commonwealth. Would you mind elaborating on that statement?
If we have a new operator coming into the picture, Tim King, the process that to require the transfer of the license itself, they're given 9 months, but the commission has already started the process of looking at what we need to do.
Okay.
I am not quite sure at what stage the lottery commission is to prepare themselves to do the vetting of Tim King. We have an entity, the Casino Commission, created by statute, trained by profession, able and ready to proceed. To disrupt the system would delay and would further frustrate our ability to carry out what we were created to do.
Okay.
That's what the intent of that.
Okay.
And I'd like to echo what Senator Carr was saying. I still believe too that our gaming laws need to be amended because I think it's still unrealistic, even with Team King. And even my inquiry to the council representing us is, do they understand that the law requires that they construct 2,000 new hotel room? So even though you win the bid, the law still says you must build 2,000 new room, invest $2 billion. Initially, they were hesitant about being able to go beyond the Garapan facility. So I think that in order for Team King to succeed, the legislature need to sit down, maybe even with Team King's representative, and say, look, you won this stuff, you won the bid, what can we do to make it successfully operate? They're saying that this is prior to them winning the bid, and it was still under IPI. 15 million a year is excessive, particularly in our time. 2,000 new rooms is unrealistic. They cannot even find construction workers. The requirement for 5-star status, it is very difficult to get 12,000 to 15,000 employees for the 2,000 room to meet 5-star quality. So all of those things I think needed to be amended. And when you amend it, then we need to look at the license agreement and amend the license agreement to make it work. So it almost like an orchestra where things must happen in a certain way. So if Tim King, and I suggested to the legislature earlier that amendments should be made now and not wait until something happens. And I was suggesting a language in one of the amendment to say that this new law will come into effect if any of these 3 conditions occur, which either one happens first. One is the expiration of the license agreement, which was like 30-some years, the revocation of the license by the CCC, or the voluntary surrender of the exclusivity by the licensee, which either one of these occurs first. Then that law that presumably is already in place will come into effect. IPI has expressed a desire to give up exclusivity, but it could not by law give up exclusivity because there's only one license. So if you voluntarily give up exclusivity, you voluntarily give up your license. There's only one license. And then the legislature at the time was reluctant to change because it is a contractual right of IPI, of which they were exercising the right to protect their interests. So if we do the necessary amendment, as we previously discussed, and just put that provision in there that these laws are coming into effect when either of these 3 occurrences happen, which either one comes first. At that time, they were ready to give up exclusivity. They were prepared to sign off to say we will remove exclusivity. But they were not allowed by law to give up the only license. So it's like they're surrendering their rights to the license. But I believe, similar to Senator Carl, we do need to amend the casino license. And if this body desires to make amendment, that would be the proper forum rather than an executive order. Because you would have a greater latitude, more time to look at it. You can get more input from the community, more input from the lottery, some more input maybe from the CCC. And maybe we can even invite in some of the CCC employees who are actually doing the work to testify and let you know what really transpires and as part of the regulatory responsibility.
Thank you, Chairman.
Can I ask to Madam Chair that my June 12th letter be incorporated to the record?
Absolutely. It's already part of the committee records. I'm not sure if this is something that you could answer, but this has been the question that I've had for a long time now, because I don't even know how we got to this point, right? As you explained earlier, the Casino Commission regulates the casino gaming part of the casino. And from my understanding, the Lottery Commission was supposed to create the Casino Commission, and subsequently will kind of dissolve itself within the casino industry. And then it would be the office of the governor that enforces the casino license. So from everything that we know and we've read, the IPI has violated a number of sections in the casino license. And so it just boggles me, and I don't understand why, if someone violated sections of the agreement, wouldn't that be enough to justify the revocation of the license itself? They've already breached the contract by not paying the license fees, by, again, we can name all the violations that they have committed against their own license agreement. Is there a reason why the license is still, in the where it is right now? I mean, I think if we simplify the contract, the license agreement, between two parties, if one of the party violates the agreement, then there's a breach of contract. And when there's a breach of contract, you no longer have exclusive rights to the license.
Like I indicated earlier this morning, the casino, Public Law 1856 is the Commonwealth's first experiment in integrated resort. This is a very huge project, never before done in the Commonwealth. And I think rightfully so that it places the burden on the governor, since the governor oversees DPS, DPW, and all of the other regulatory entity, and it puts gaming under the Casino Commission's responsibility.
Right.
And I indicated to you earlier that IPI's performance in gaming was exceptional.
Right.
But in their performance with everything else was very disastrous. On the labor issues, on the construction issues, on a couple of other non-gaming issues. And I was told by the Attorney General when I asked, why is it that the CCC always gets blamed when anything IPI does? And his response to me at the time was, it's because CCC is the only entity that enforces the casino license agreement. And I wonder sometimes, where was the Lottery Commission? Why didn't they enforce their own agreement that they executed? Where was Public Works when the building code was not enforced? Even though we asked Public Works, we used to invite them every month. They show up in our meeting, and every month we go through and they know what the violations are. They just, particularly with the issue of the crane, it took forever for that crane to come down.
Right.
It was a Public Work issue, not a Casino Commission. And IPI had lawyers that threatened us left and right that we have no jurisdiction. Labor issues, we don't have labor issues.
Right.
We have a CNMI Department of Labor, a U.S. Federal Department of Labor. CCC comes in secondary.
Right.
We have the authority to help them enforce it. We don't have authority on the ports of entry, yet we get blamed when there's somebody working there with not appropriate power authority. So in the exercise of implementing our first major integrated resort, 2,000 new hotel room, 5-star quality, $2 billion investment, $100 million entertainment team, convention center. It includes significant amount of other government agencies' jurisdiction. And I reached out even to the former governor. I said, look, this is very large. We need to have like an ad hoc committee. And since we did not have an active ad hoc committee, every month when we meet, I invite all the secretaries of all this department to come into the CCC's monthly meeting, and we all, entertain the discussion. In fact, when IPI was preparing to move from the T Galleria to IPR, I told him that you will not be able to move until I get all the proper permits from all the regulatory entity, and until I'm actually holding the permit, whether it's a food handler permit, a fire permit, the building code. We have other issues with the building code because they said they never issue a building code in an unfinished building. So they issued a conditional occupancy, which really did not exist at the time, only after they amended their regulations. but we have so many permits before we allow them to open the IPR, including business license and so forth. Now, I don't know. There's several sections of the agreement that really is almost non-enforceable. One, there's a section in there that says that if you ever go to receivership and you sell your gaming equipment to the point where you're no longer viable for gaming, that constitutes a violation of the agreement that can subject you to revocation. They agreed at the time that they signed. Another one, if you file for bankruptcy, that is considered automatically a violation of the agreement that you would lose your license. But those are meaningless in the court of law. When they file for Chapter 11 bankruptcy, the fact that we have that provision in our casino license agreement is irrelevant. So on the surface, you made it look all this time that, hey, you're in no position to file for bankrupt. If you do, it's almost a prima facie kind of law where on the surface you violated it, and therefore we will revoke your license. And no, federal law trumps state laws. I even communicated with some of the casino regulatory entity in Nevada. I said, how do you deal with operators who file for bankruptcy? He goes, that's a very difficult situation because that's a federal law that protects the vendor who's asking for protection. So the state law that enforces that kind of below the federal protection. So that, and a lot of people don't understand why does CCC revoke it? Revoke it now. We tried, and we're still trying, and if we still think we are already done with the revocation hearing, we're in the deliberation state, and as soon as that window opens, we will revoke.
So let me just ask one last question before you wrap up. Is the Casino Commission the right entity to pursue the revocation of the license, given the explanation that the CCC is the enforcement authority, right, on the gaming side, not on the non-gaming? The non-gaming would refer to the everything else that's on the agreement. Is the CCC the responsible entity to pursue the revocation of the license?
I think it is, and we already conducted the revocation hearing with
Right.
IPI's own lawyer representing them.
Is that what it states in the, I don't know.
We have above 1856 and I think 21-38 that allows the Casino Commission to revoke the license, given that it is clear and substantial. There's that legal term for it. So it does authorize the Casino Commission the authority to revoke the license.
So though the office of the governor is the one that enforces the license agreement, it is the Casino Commission that pursues the
revokes,
revocation. Okay,
Yeah.
and that's clear in the law. Okay. That's all I have at this time, member. I recognize Senator Donald.
Thank you, Chair. I don't have any questions, but I do have recommendations and suggestions. Well, I appreciate your recommendations, Chair. Can we get that in writing to the committee as to what are some of the recommendations that could be made in amending the casino law to include some of the ways in which we can address what the governor had listed in the executive order in terms of what are ways we can cut costs maybe, or separate the argument that there's duplicative efforts. And so those are stuff we can incorporate, and that would provide some of the members, whether in the Senate or the House, more confidence in that if this is something that we can introduce at the time we are going to address the EO, then you may get that support in rejecting the EO, provided that we are trying to address this issue legislatively, so that could also address some of the concerns that are being brought forth from the community. And so if that's something that you and the rest of the commissioners can provide to the legislature, then we'll certainly take that into consideration.
I may add that CCC is supposed to be funded by the regulatory fee by the operator,
Right.
and we still stand behind that. IPI currently owes us over $20 million, and we always intended that we will use that to pay off all of our obligations on the rental and all of the back pay.
Right.
And it was with the grace of God that some of the members of the legislature stepped forward and say, we notice that some of you are really suffering. There are two retired already, and I understand they're very loud too, because there's some statement that they themselves may sue CCC, those that have retired, and according to the law, Office of Attorney General must indemnify CCC, must defend us when when the commissioner sues us for non-payment. So, but we always
And I understand it, and we value the work that is being
Yeah.
done by the CCC, but also, I mean, as you may have been aware that even within the municipal level, the RCGC, we've made significant changes to what to expect in the event there's no active casino license, or how do we proceed moving forward in terms of uh, increasing liabilities, and so we've tried to address that on the local level. So now, how can we address it within CCC so that we don't come across this issue in the future in the event licensees, go back on their word, or
I will do that, sir. I will submit that. But just for your info, on this new Team King, I was informed by our council that we can still work and negotiate to cure the deficiencies. So we know how much they owe us. So to negotiate, we anticipate that they have to pay CCC both the regulatory fee and some of the startup application fee to do the due diligence. So we don't anticipate, burdening the Commonwealth on that obligation. And it should be like that, and we do not disagree in that direction. That it should be the operator that pays for it. And we've been quietly sitting down and hoping that this will be resolved. And we're on the verge, in my opinion, of resolving this and moving forward. Now is not a good time to disrupt the system.
and I agree. And so, like you said, it was experimental in a sense, and so those are stuff that we can incorporate into this new amendment. Should one of the members introduce it. Additionally, Chair, may I request that before we meet with the Lottery Commission, if we can, I appreciate the presence of our Assistant AG, but since he wasn't invited to attend this meeting, if he can make himself available with DPL maybe prior to the meeting with the Lottery Commission, that way we can kind of see what's going on between those two entities, and then bring in the Lottery Commission. So.
We are not privy at this time to find out what's going on between Team King and Public Land, or what's the status of Team King.
Correct.
But perhaps the council is. So
Right, and that's why I was asking the chair if we can bring in DPL also to see what's going on there.
Yes.
Thank you.
Great suggestion, Senator.
Thank you.
Senator Calvo, do you have any last closing remarks before we leave for the day? You're good? Okay. Chair, any last remarks before we close for the day?
thank you, Madam
No,
Chair.
thank you, Madam Chair, and thank you.
Oh, I'm sorry, Senator Carl.
no.
Did you have any last statements before we call it off for the day?
No, ma'am, I don't. I just wanted to say thank you again for making your time available, and we appreciate your suggestions, and we will take them into consideration as we move forward.
Great. Thank you, Senator and Chairman.
I just wanted to say, Madam Chair and members of this committee, thank you too for the opportunity to have this session. The CCC has invested significant amount of time, resources, and money in building up our regulatory infrastructure, and I feel very strongly that the CCC from 2015, 16, 17, 18, we're doing a very robust regulatory regime, and you can see that in terms of the outcome of the revenue that was coming into the Commonwealth. Unfortunately, the operator had confronted numerous challenges, both environmental challenge, YouTube, and then COVID, and some other challenges, and labor issues and construction issues and so forth, that started crumbling. We saw the need to amend 1856, and I reached out to you previously to say, I think we need to take a look at it, and we did this months ago. We don't need to wait until it collapses. We did it at the House too, but mostly during budget hearing. But we are reaching out to you to say, we ask you to please reject this executive order. This is not the proper way to go. Do we need to change the statute, the gaming statute? Yes. Let the legislature have more time to digest the changes and make, because I think we need to stop making reactionary laws and start making kind of a proactive, well thought out laws. And the way to do it is to get enough time, not 60 days, to think about the implications. And in doing so, you may want to consider Rotantinian, because the Casino Commission has a Rotantinian component into it. And I think whatever outcome we do on Saipan, the experience that we have, the system that we'll be implementing, I think will also be useful for Rotantinian. I know that we have extended training to the Tinian gaming people at our CCC office, and they were tremendously appreciative of the exposure to all of the different component of that mix. They were mix for them was strange, was a new document, but when they understood that this is standard operating procedures that they all need to understand, because when you walk into a casino, you should know what you're looking at as a regulator. And you don't have to know it all by yourself, but there are different components of the regulatory body that would be responsible. I know that a lot of people don't understand, but our audit division, headed by Charlie Atalik, was one of the more awesome divisions that even revenue and tax were shaking their head. Even the 4 CPA from IPI were shaking their head, because we were after them to make sure that they were reporting their income. Every day that they drop, there's a report submitted to us. And at the end, when they file their BGR, we have our staff looking at whether or not that BGR coincides with the proper drop. So this is really, it was working well. And I see no reason why we should stop it. It was only stopped because of lack of payment. And we have no CNMI funding. We completely rely on IPI's regulatory fee. So when that stopped, our regulatory enforcement capability stopped too. And we spent a significant amount of time with the civil division of the AG's office, litigating it to the arbitration, litigating it to the revocation hearing, and so forth. I will take my hat off to the civil division of the AG's office. They have been very helpful, since the former chief, John Laurie, to the current chief, Nelson Allison. Been very, very helpful people, and I take my hat off to the office. They were the ones helping us negotiate to the very last moment prior to them filing the bankruptcy. But that's a different story, maybe for a different chapter. But I look forward to working with the body in terms of looking at ways on how we can amend the statute to make sure that it reflects what the community need, and it protects us in terms of any other abusive operators. Thank you again, Madam Chair, and honorable members of the Commission, for the opportunity to appear before you and share some of our experiences on this, and to allow us to ask you to reject the EO. Thanks again.
Sidus Dangkulo na Sidus Masi, Chairman. Ni Tempomu and si Mr. Commissioner Taitano, thank you for bearing with us. We appreciate all the information that you have shared with us. The committee will take all of that into review and consideration and deliberation, and we look forward to meeting with the Lottery Commission, as well as take the suggestion from Senator Donald to invite DPL and I believe that's Chief Solicitor Robbie Glass in the back. Yes, definitely take that suggestion. And so with that, Undangklo na si Jus Moasi for coming in and answering some of the questions that the members have. And should we need more information from you or have any more questions, we will definitely reach out. So thank you for your time, and you are now dismissed. Thank you. Members and staff, I would like to take this opportunity to thank you as well for being here and for providing the support that we need, staff. At this time, if I could get a motion to adjourn today's committee meeting.
So move.
Second.
Thank you. A motion has been made and seconded. All those in favor say aye. Those opposed say nay. The motion carries. Today's joint committee meeting is hereby adjourned at 5:09 p.m. Thank you very much, everyone.